Okay. All right. We are, Samantha, whenever you're ready to start, let me know.
Give me 1 second, Judge.
Sure.
Can you help me out? Oh, it says it's here.
Okay, Judge.
All right. This is the Asenova case. This is 2020CV333774. Today is January the 13th, 2021. Happy New Year, everyone, by the way. And
Happy New Year to you, Judge.
this is the continuation of an injunction hearing or a motion to extend an injunction hearing that we began on December the 16th, 2020, but were unable to finish. So we are resuming today. I have put, everyone is appearing via the Zoom teleconference platform, and I have put us on the court's YouTube live stream channel, just so we continue to meet our obligation to keep the public's business open and accessible to it. I believe we left off on December the 16th with the cross-examination of Mr. Miller. If there's nothing else we need to discuss, I'll let you proceed with that.
All right, good morning, Your Honor. I will pick up with Mr. Miller's cross. I'm in the process of just sticking my exhibits back in Dropbox, so I plan on just using a few, and I'm hoping by the time I get to them that it'll be a seamless transition, so just to hopefully to avoid any delays. Mr. Miller, if you remember, you're still under oath.
Okay.
Okay. We spoke last time at the hearing about the level spreader, and you agreed that the water flowing from the pond at the highest discharge point, you said the level spreader is acting more like a splash pad. You remember that?
Yes.
And you said that once the water hits the splash pad, it's no longer concentrated, correct?
Yes.
And correct me if I'm wrong, the whole idea of the plan that you designed is for the water from the pond was to take accumulated water, have it leave the pond and become sheet flow over the 20 feet between the end of the pond and the Asenova property, correct?
Yes.
And we discussed last time that the water that is leaving the top opening, which is the only opening now that remains, has resulted in, at times, where the distance between the final discharge point of the water and the Asenova property has now been reduced to 14 feet, correct?
Yes.
Okay. Do you know what a rill is?
A rill, like a small gully, yes.
A small stream, would that be accurate?
I think a small gully would be more accurate.
What's the difference between a small gully and a small stream?
A stream maybe would imply that there's water in it. A rill, I think, is more just like the bed, but with or without water in it.
Well, if the rill is filled with water, it's a stream then, right?
Yes.
Okay. So would you agree that rill flow is when water flows in small, irregular channels?
I guess you could call them channels, yes.
And water that's in a rill flow is therefore not sheet flow, correct?
I think you're splitting hairs here, really.
I
mean, you could have sheet flow that had rills spread out throughout the sheet flow, yes.
But sheet flow in a rill could also become concentrated flow if the water is in, you called it a gully, I'll call it a rill, right?
I'm not sure what was the question.
Well, let me ask you this. Sheet flow is a thin continuous flow or downslope of water taking the form of a thin continuous film that's not concentrating, right?
I guess that, yes.
All right. And the purpose is to allow the water, or not the purpose, but the effect of sheet flow is that the water is absorbed into the ground as it flows, correct?
No.
Water does not flow in?
No, I think if it's flowing, if it's soaking into the ground, I don't think it would be flowing.
Well,
I'm sorry, would you repeat your answer?
If it's soaking into the ground, I don't guess it's flowing. You're kind of confusing me a little bit here.
well, if sheet flow is occurring, would it necessarily cause what you called a gully, I'll call a rill?
No, not necessarily.
But it could cause, sheet flow could cause a rill, correct?
Yes.
Before this detention pond was built, are you aware of any water that flowed from Pinemont to the Asenova property that was concentrated?
No.
Okay. And would you agree that the water that came from Pinemont flowed from Pinemont onto the Asenova property along the entire length of, I'll call it the border, following the contours of the property, correct?
Yes.
Okay. So we looked earlier at some videos from September and October of 2020. Do you remember those videos? I'll show them again. Let me just share screen. Where do I find it? I have to open it. Do I share it first or find it first? Is that the one you just added?
Yeah.
Where are they?
Your Honor, while Mr. Mirbaum is looking, I'll object to this video. It's already been shown as duplicative, cumulative.
Okay, well, I don't know what it is, so
Well, he said it was. He said we already seen it.
Well, but I have some questions about it, and it's based on your
if
direct
it's in
examination.
evidence, if it's in evidence, you can go ahead and question him. What I was concerned that you were saying is that we did not have this one before. And I just wanted to make sure everybody knew, because this was continued from December the 16th, we're not starting all over.
Now I do share screen.
Yeah.
Where's that? That's back here. Oh, I see. No, this is post-attended. It's here. That's not what I want.
Yeah. Okay. There you go. Go back to that one. They should be able to see your screen now.
Okay.
There you go.
All right. Sorry about that. This is maybe by the next pandemic, I'll figure out how to do this better. So this is the October 11th video. I'm going to skip ahead to the what's the 34-second mark. So I'll just go a little bit before that. All right, so my question is what you're observing here, and I'll keep running it, Mr. Miller, that's not sheet flow, right?
I really can't tell from that video.
Well, I'll run it one more time. You see how the water is flowing and causing erosion? Do you see that, or you disagree with that, or you can't tell?
I can't tell that. I can say though, where it's coming under the fence, it looks like it's spread out pretty well. And maybe once it gets on you know, on the property we're looking at, maybe it becomes concentrated. I don't know, but where it's coming under the fence, it's spread out. Yes. And I don't see any erosion in that video you just showed.
All right. Let me show you. No, I want to go back to another video. Where do I find the other video? Okay, so I'm going to show you is that one in here, or we just put one? All right, I'm going to skip this video. We'll get another one in a bit. Where does it go? Okay. You agree that, so you prepared the site plans for the project. We've discussed that, right?
Yes.
And I think you said the goal for the development was to maximize the number of buildable lots.
That would be one of the goals, yes.
Okay. And there's no dispute that the site plan calls for there not to be an increase in water runoff onto adjoining properties, correct?
Yes.
And the plans, a review of the plans and based on the information you've been provided, is it true that at no time prior to the construction of Pinemont was water accumulating into a detention pond located 20 feet from the Asenova property?
That's correct.
And prior to the development of Pinemont, you never spoke to the Asenovas, correct?
Correct.
And during the first hearing, showed you the video where Mr. Asenova put a shovel in the ground and it's filled with water. Do you remember that, or do I need to put it up again?
No, I remember that.
Okay, and you don't know if the condition that existed in that video, it existed at any time prior to the development of Pinemont, correct?
Correct.
And you don't know if any of the erosion that the Asenovas are now complaining about occurred prior to the development of Pinemont, correct?
Correct.
And the plans that you designed call for an infiltration system,
Yes.
and that system is still not online, correct?
I believe that's correct.
Then the idea of that system is to hold the first 1 inch of rainfall, and anything after the first 1 inch then goes into the detention pond, correct?
Yes.
And up until now, all of the rainwater is going right into the detention pond, correct?
Yes.
And that's because the infiltration system is not online.
That would be correct. Yes.
Now, you said you've developed plans for many other subdivisions in Georgia while working at ACR.
Yes.
And at the last hearing, you said that the pond always discharges into adjacent property. Do you remember that?
Yes.
But adjacent property is not always residential property, correct?
Correct.
And it's certainly not always residential property that's 20 feet away, correct?
Yeah, correct.
And discharging water to adjacent residential property that's 20 feet away is rather unusual, correct?
Not necessarily.
Well, is it less than 20% of the time?
I don't know what percent.
Would you agree that discharging water within 20 feet of residential property creates more concerns as opposed to discharging it onto undeveloped property or directly into a stream or some other sort of collection basin?
I think you'd have to be aware of it and take proper measures to make sure you didn't cause a problem in that case.
During your testimony, you spoke about closing the lower 2 openings to eliminate discharge of smaller storms. You remember that?
Yes.
And you said that a 4 1/2 inch rain is a 5-year storm, and that has the possibility of happening 20% in any 1-year period. Did I understand that right?
That sounds right.
Right.
I'm not looking at that note
Okay.
right now. That sounds right.
Would you agree that 20% of 1 year is 73 days out of the year?
Yes,
So on 73 days each year, based away on the storm now, there's a possibility that there's a 5-year storm.
wait, what now?
73 days out of the year, there's a possibility there's a 5-year storm.
That doesn't seem to make any sense, no.
Well, what's 20% of 365 days?
73.
Right. So, and you said there's a 20% chance over a year that there's a 5-year storm.
Yes,
Okay. Now, in all of your calculations, you did not do any analysis of the probability of a 5-year storm, say, followed by a 3-year storm or a 1-year storm in consecutive days, correct?
correct.
Now, how many days last year were there rain events over multiple days where none of those rain events were 5-year storms?
Could you ask that again?
How many days last year were there rain events over multiple days where none of those rain events were individually 5-year storm rain events?
I don't know.
And you also said that a 5-inch rain event in a 24-hour time frame is only 10 to 15% likely. You remember that?
I don't remember, but that sounds right.
And you did not do any analysis when you prepared the site plans as to a 1-inch rain for 5 straight days, correct?
No, there's procedures we've used for analyzing all this that are standard throughout the metropolitan area. And I mean, I guess there's an infinite number of combinations of rainfall rates and amounts and how often it happens and everything. So it's what we do, analyze based on what those regular regulations are. So if you want to ask me, you know, did I do 3 1-year storms and then a 2-year storm? No, none of those.
Okay. The plan you design is to make sure that the peak runoff of water leaving the detention pond is not greater than the peak runoff post and pre-development, correct?
Yes.
And that design included a 1-inch diameter opening out of the detention pond and 2 6-inch diameter openings spaced a few feet apart, correct?
Yes.
And as we sit here today, the 2 lowest openings have been closed, right?
Yes.
And that resulted in the pond holding 108,000 gallons, more gallons of water than it did before the lowest outlet was closed, right?
I don't think so. I'm not sure what you.
Well,
It's not holding any more water. Maybe it's holding it for a longer time.
So this was the status report filed, which we looked at previously, defendant status report. It says, as a result of the 2 changes noted above, the pond will detain without discharge a total of approximately 108,000 gallons more than it could hold in early June. Is that correct?
That doesn't sound like it's worded quite right.
Well, I didn't write it. I'm just reading from the status report. We introduced this as an exhibit last time. This was filed in August after the 2 lowest outlets were, or the lowest outlet was closed, and then the analysis of closing the next. I'll go a paragraph before. Late in the first week of this month, the city of Alpharetta approved permanently shutting off the next highest pond outlet, which is located 3 feet above the one previously shut off. Defendant has now shut off that discharge outlet as well, increasing the detention pond volume by a further 48,000 gallons. And then the next paragraph, which I just read, as a result of the 2 changes noted above, the pond will detain without discharge a total of approximately 108,000 gallons more than it could hold in early June. Is that still accurate?
It will detain that amount without discharge. That sounds right, but the volume hadn't been increased.
No, I didn't contend the volume of the pond was increased, just the amount of water it could hold without discharge.
Yeah, that's correct.
Okay. And you would agree that if the pond is full and not discharging, if there's a rain event, it would not take a significant amount of water for the pond to discharge either from the top orifice or through the weir, correct?
Through the orifice, yes.
And once it goes through,
it would probably take a pretty good rain to make it go through the weir.
All right. If water were to exit over the top or over the weir, you didn't do an analysis of the effectiveness of the level spreader, the riprap, or the hay bales, correct?
Yeah, they would be adequate for any of those rain events.
So the level spreader, the riprap, the hay bales would serve to convert the water overflowing either over the weir into sheet flow within that 20 feet space?
Yes. No, and really the hay bales are not part of that system. That's just, that was kind of a temporary thing put in there during construction. The level spreader and the riprap will accomplish that.
You've maintained since day one that the design that you created has not created additional concentrated water to the Asenova property than it did before Pinemont was developed, correct?
Yes.
And that's from the day the pond was completed and started to hold water, correct?
Yes.
And all of whatever actions have been taken by the developer since the pond was completed were, just so I'm clear, they're not a recognition that there's an increased concentrated flow, but to try to minimize water discharge from smaller rain events, correct?
Yes.
Okay. So I want to go to a video. I want to share it. Screen share. I got it. So this is from the first video. This is from February of 2020. This was when the lowest pipe was open. Remember we looked at this one? Okay, I'm going to skip ahead a bit. So right here, you'll see basically a hole, a gully, whatever you want to call it. This was not present at any time before Pinemont was developed, correct?
Are we looking at that? Looks like a mud puddle kind of.
Well, here's a better view of it. I think that's a pretty deep puddle, but that's your testimony, not mine.
Yeah, that looks like the Pinemont property under construction, as far as I can tell from
Right.
that.
And clearly, whatever this is, a hole, a puddle, it's holding water, correct?
Yes.
Then would you agree the water is at least part of it absorbing into the ground?
Probably.
This was never part of the plan, correct?
Not really.
All right. All right, now this was Exhibit 18. No. Share screen. Share. All right, this was Exhibit 18 from the first hearing. I'm going to skip ahead. So we spoke about rills and streams just a little bit ago today. Would you call these streams?
I don't see what I would call a stream, no.
Would you call it a rill?
No.
You don't, so it's your testimony, this is still sheet flow that's being shown here?
From what I can see from this video, yeah, I would call it sheet flow.
And sheet flow would create little crevices in the ground where the water stays in a concentrated form?
What? I don't see any crevices or concentrated form. I'm not sure what you're trying to say.
I'm not trying to say anything. I'm just asking the questions. Let me show you this one. It's the last one we're going to look at. Close this. Where can I find that? Let me get carpal tunnel syndrome. Exhibit 15. Go here. I'm going to go share. I go here. All right, and this we looked at. Can you see this video, Mr. Miller?
Yes.
You still think this is sheet flow and not water that's in a rill or a stream?
I don't see a stream. I see it's coming out. It looks like through a pretty wide area coming under the fence, as far as I can tell from this video.
All right, and do you contend that this condition did not occur or occurred on the Asenova property before the development of Pinemont?
I wasn't on their property prior to the development.
Am I done sharing? Okay. All right, I don't have any further questions for Mr. Miller.
Can you redirect, Mr. Malabi?
Thank you, Your Honor. I have a favor to ask of Mr. Mirbaum. That last video that you just showed, do you mind showing it one more time? I may be able to do it myself, but thank you. Can you stop it right there? Can you stop it? Stop it?
I did.
Okay, thank you. I appreciate that. Yeah. Mr. Miller, do I have you?
Yes.
You just testified that the water is coming from the Pinemont property onto the Asenova property, apparently under the this wooden fence, appears to be fairly well distributed, and therefore you would call it sheet flow. Is that fair? Is that appropriate?
Yes.
Can you see these? I don't know what to call them. Plant beddings with little brick. What's the right word for that? Surrounds at these planter areas. Can you see
I'm
the
sorry,
brick?
what about them?
Can you see them, first of all?
Yes,
Can you,
yes.
do you know what I'm referring to?
Yeah.
Are those concentrating the water?
Yeah, it looks
on
like
those-
instead of continuing on down in sheet flow, it's getting up against that and flowing alongside those bricks or whatever they are.
Okay. Thank you, David. I have a few questions on redirect. There were some questions put to you in December and again this morning with regard to the impact of closing the two lower discharge outlets, right? And the fact that there's really just one opening in the detention pond wall for water to come out now, and that's the highest one. So far, so good.
Yes.
And then I think we saw a video that Mr. and Mrs. The Asenova had put together or showed, indicating that the water, as it came out of that top discharge hole, was coming out at some significant pressure, such that it at least some of the water appeared to be missing the level spreader down below. Is that correct?
Yes.
Are you concerned about that?
It looks like it would still probably be effective enough to convert it to sheet flow. I think if there was some concern about that, we could probably put like an elbow in that opening to turn the water and make it go straight down to where it would be able to use the full length of the level spread.
So you could put attach an elbow at the discharge hole.
Yes.
Then pull the water straight down, coming essentially vertically, so none of it misses the level spreader.
Yeah, so it would hit the very beginning of the level spreader and have even that much more time to spread out.
Okay. Forgive me a second. There's been some, there have been some questions put to you before and again today with regard to the distance between the far side, the downhill side of the level spreader, and the property line, how far that typically is or can be if you're dealing with a residential property. Is there anything in the design manual that civil engineers use to design these kinds of systems in Georgia? And we've talked about that before. Or any other engineering standard that civil engineers use for this purpose that says that a level spreader cannot be within 20 feet of the adjacent property, whether it's residential or otherwise?
No.
Is water coming from the Pinemont property the only source of water runoff that goes into the Asenova property?
No, it's not.
Is there anything that you as an engineer did or feel like you should have done in order to account for water from other properties going onto the Asenova property?
No, there's nothing we could have done about that.
You were just asked about, again, the 20 foot and, is it appropriate to have a discharge from a detention pond within 20 feet or 16 feet or 50 feet of adjacent property that's residential? And I thought your response was something to the effect that that is not problematic, provided you take measures, appropriate measures. Did I hear you correctly?
Yes, that's correct.
And in your design, did you do that?
Yes.
And what was that?
That was, in addition to the detention pond that attenuates the flow, we put the level spreader and riprap to make the flow that does come out, convert that back to sheet flow.
Okay, there was also a question put to you with regard to water exiting the detention pond from something called a weir.
Yes.
Could you just briefly describe what that is?
That's, I guess you would call it a notch in the top of the wall where the water starts coming out through the 6-inch orifice, and then when it gets to the notch, to the weir elevation, then some water will come over the weir and then flow down the wall.
I'm sorry, you're saying, what is the word, weird?
Weir, W-E-I-R.
But can I just ask, what are you saying, knots, K-N-O-T-S, or notch?
Notch.
Okay.
So, are you aware of water from this detention pond ever escaping it through that weir? Do you have any information to that effect?
I do not.
You were shown video from February 2020 showing a puddle on the Piedmont property. I didn't catch what exhibit number that was. I think you called it a puddle, and you indicated that was during construction. Do you recall what I'm talking about?
Yes.
Okay. Does the presence of that puddle, or whatever you want to call it, that feature, that body of water, in any way suggest that there is an increase in runoff to the Asenova property from Pine Mountain?
No.
Does it in any way suggest that there is concentrated water from the Pinemont property onto the Asenova property?
No. I think all it is during the grading process, the ground hadn't been smoothed out right there. And, little localized low areas, what I saw in that picture you're talking about.
That's all I have. Thank you.
All right, cross it, any recross?
No, Your Honor.
Okay, thank you. All right, Mr. Malavi, any other witnesses?
No, ma'am. Thank you.
Okay. Do you have all of your exhibits in, or are you essentially tendering? I think we may have already done that, but is there anything further you would like to do with regard to documents or evidence?
Is that me or Mr.
No.
Malavi?
That's Mr. Malavi. This is the end of the defendant's case. So
I would. I noticed in the transcript when arrived from the court reporter that there was indication that there was about a half a dozen exhibits that had been introduced but had not been tendered, and I would tender all of those.
okay. So the tender of half dozen exhibits.
And well, I can tell you exactly what they were. They're in the transcript. I may have just one moment.
Now, I will say part of the issue may well be, and Samantha can go off the record and correct me if I'm wrong, but the issue may be that I was down at the courthouse with the exhibits and she was preparing the transcript from another location. I don't know if that's the case. Can we go off the record for just a minute, Samantha?
Mm-hmm.
Do you physically have the exhibits?
No, I don't have any exhibits, Judge.
Okay, let's go back on the record. So the court reporter has answered the court's question, which is she doesn't have any of the physical exhibits. Some of them I printed out at the bench. Some of them you're going to have to provide. Well, I guess I could. You see, the Dropbox links expire. That's my concern. So we will, for purposes of any further proceedings, have to make sure we have all those videos. The documents I can print out, and that's not a problem. Except I think there were a couple of plats that were probably very large, but I can figure that out. But the videos we have to make sure we have in some transmittable form to go with the transcript. But go ahead and give me those numbers, Mr. Malavi.
Your Honor, looks like I had exhibits marked D as for defendant, 209, D210, 211, 212, 212A, and then I went backwards to 208, 207, 202, 203, and 204.
Okay.
And I can submit all of those. I don't believe any of those were videos in my case, so at least that problem I don't have. And I did have some drawings, but I don't think they were very large volume drawings. They were cross sections, as I recall.
Okay.
And I can retransmit those to the Madam Court Reporter, to the court, as you may instruct.
Let me just go over. Are you tendering the exhibits that you just mentioned?
No, I didn't hear you. My apologies.
Are you tendering the exhibits that you just mentioned, 209, 210, et cetera?
Yes, ma'am.
All right. Any objection, Mr. Beerbaum?
No, if those were the ones that were identified at the hearing, I believe there were more that were originally included in what was going to be introduced. So is it correct, Mr. Malabi, that there are some that you originally planned on using you did not use?
That is correct, Mr. Urban.
Okay,
I had some exhibits there that I ended up not using.
All right, so if these are the ones that are identified at the first hearing on the transcript, I don't object.
Okay. Well, let's just for the record, because somebody's going to be reading this one day, and let's just say that the tender has been made for 209, 210, 211, 212, 212A, 208, 207, 202, 203, and 204. Any objections to those exhibits, Mr. Beerbaum?
No.
Those are admitted into evidence without objection. Now, I did have for the defendants at our last, no, that's back in May. Okay, so that's, okay. That makes more sense. Let me just check one more place. All of the ones that we just admitted were in fact, I think, identified. So those are admitted. Anything else for the defendants at this time?
All right, I'd like to have a very brief closing statement if you're so inclined.
Give the plaintiffs a chance for rebuttal, but anything further, do the defendants rest?
Defendant arrests, and I'd like your permission to excuse the witness.
Sure. Thanks, Mr. Miller.
Mr. Miller, you can stay on if you wish, but you don't have to.
Oh, okay. Well, I guess I'll stay for now.
Okay.
Just
Mr. Beerbaum, any brief rebuttal?
No rebuttal.
Okay. Mr. Beerbaum, you have the right to open and close.
I'll waive opening.
Okay, Mr. Malabi, any closing argument?
Yes, Your Honor, thank you. I'll just try to be very, very brief here, Your Honor. The plaintiffs have sued my client for trespass and nuisance, and the court presumably will deal with all that when the case is tried.
I'm sorry, Mr. Malabi, would you repeat the last thing you said? And also, I'm hearing some other noise in the background from you.
Yes, you are. That's my yard people are blowing the yard. I'm going to go tell them to go away. Just give me a second.
Let's take about a 5-minute recess because that is coming through loud. And the blower.
My apologies for that.
Loud and clear.
My apologies. Sorry.
What's the guy's name?
I'm back whenever the court's ready, Your Honor.
Go ahead.
Thank you. Yeah, my
Oh, one
apologies for
second.
that.
Ooh,
One
I'm sorry.
second.
I'm
One
sorry.
second.
I had told the court reporter to take 5. I apologize. That was on me.
Okay.
This is
Okay.
not for the record, Your Honor, but pandemics and impending civil war don't seem to stop the leaves from falling into one's gutters. So
Understood. I'm jealous you've got somebody there.
I can send you a name and number if you wish. So I'm going to start from scratch. This is a lawsuit about trespass and nuisance, and that will be addressed when the case is tried. Obviously, we have an injunction hearing here today, and the relief that the plaintiffs have formulated and they're asking you to issue was nebulous before, as I think I mentioned back in May when we met about this, and it's still very nebulous. It's not really clear what they want. What is clear is that the plaintiffs have a problem with their yard. That's real. But they've always had that problem. They've always had a problem with water flowing into their yard. What they're contending, of course, is that there's something that's different right now. But in support of that, you know, you've seen videos and testimony. The videos were all created after heavy rains, including Hurricanes Sally, Delta, and Zeta. And I think it's common sense that under those kinds of circumstances, their yard would not have been dry. That's just impossible. So I'm not giving their issues short shrift, but they have the burden of proving that they have a problem that was caused by the defendant, and it was not. All the work that was done on the Pine Mine property has been done to date and will be done going forward, is based on a set of engineering drawings and hydraulic calculations that were reviewed and approved by the city of Alpharetta. And to this day, you know, from the very beginning of this case, before a lawsuit was filed, we asked for an engineering analysis showing why the plaintiffs think that Pine Mine has had an adverse effect on the property. To this day, you have not seen a single calculation by an engineer on their part showing you that Mr. Miller's design was incorrect or insufficient in any way, shape, or form. He's explained that he made every effort to, and that's his job, to make sure that the water is controlled. That's not only is that his job, that is the job of the detention pond, is to control the water. And that's what's been done. But even if the Pine Mine property had any adverse impact on the Asenova property, there's just not enough information before the court to make that decision at this point. The plaintiffs are being deposed next week. I have not had an opportunity to depose them yet. Their consultant, Mr. Ray, is being deposed this afternoon. I have not had an opportunity to depose him. They have presented evidence of water in the yard, and I'm sure there was water in the yard, but they've presented no evidence of what their yard would have been like prior to the Pine Mine development. The only, again, you have no calculation, no engineering work showing any adverse impact. The only evidence of that impact that you have is their say-so. You know, Mr. Mirbaum repeatedly asked Mr. Jalali and Mr. Miller whether they had ever been to the property before this development, as if they could have known, you know, what the yard was like, how the yard was used, and what they could do before that they can't do now. But setting all of that aside, even if you totally believe the plaintiffs, their understanding, their perception of there being a difference between now and before, you still can't give an injunction because they have not demonstrated that they do not have an adequate remedy at law. And that's a requirement for an injunction. And finally, I would say that even if the court is inclined to grant a TRO, a reasonable measure, the only reasonable measure that's been proposed is to require the defendant to control the direction of water and the manner in which it exits the detention pond by installing an elbow and a pipe outside the detention pond so that the water does not jump over the level spreader, and so all of it goes into the level spreader. So that's if you're inclined to do anything at all, that's what I would ask you to do. Thank you.
All right, thank you. Okay, Mr. Beerbaum.
Your Honor, this injunction is based on two legal theories, a nuisance and a trespass. And this is not based upon recent events from September and October, which were heavy rains, but certainly not rising to the level of 100-year storm rains. They were heavy rains, but the issue has taken place ever since Pinemont was developed and the Asenova started complaining in January, which led to the lawsuit and the complaint and the first injunction. And contrary to what Mr. Malavi says, they're not complaining that their yard is not dry. No one's ever said that. Clearly, when it rains, the yard gets wet, but never to the extent of what is happening now and what has happened ever since that detention pond was built and that water is spewed out of that pond in an incredible volume at this point, with that top opening being the only one. Mr. Miller admitted that this design was never intended to turn concentrated water into sheet flow over a 14-foot space, which is now the design, as opposed to 20 feet. He also was challenged to ask about other properties he designed that discharged water of this volume to a residential property within 20 feet and couldn't name any, either at his deposition or today, or now within 14 feet. And this is a highly unusual set of facts, and they have not followed the plans to make sure that there is no adverse effect on the downstream properties, as they were required to do by law. I don't have to show that their actions are illegal or improper. That is not what a nuisance is. Equitable relief, as the court knows, is within the discretion of the court. The court has broad discretion to fashion equitable remedies upon the exigencies of each case, and a trial court can issue an injunction in a manner that is the least oppressive to the defendant while still protecting the valuable rights of the plaintiff. And this is from Rigby versus Boatwright, 330 Georgia Appellate 181. In this case, clearly the property rights of the plaintiffs are being impacted. And Mr. Malavi did mention, and I repeatedly have asked all of their witnesses if they know what the Asenovas encountered while they lived in the property, and not one of them has any evidence or documents or videos or pictures showing what the Asenovas encountered before this detention pond was built. It is uncontroverted, undisputed evidence from the Asenovas, the people that have lived there, that these conditions that we've depicted on the various videos and the photos, and digging up the yard and water percolating up and water streaming for days after rain events, never happened before this property was developed. And there's nothing that has been presented which has contradicted that. A nuisance is anything that causes hurt, inconvenience, or damage to another, and the fact that the act may otherwise be lawful shall not keep it from being a nuisance. The inconvenience complained shall not be fanciful or would not affect only one of fastidious taste, but it shall be such that would affect an ordinary, reasonable man. Now, I did ask Mr. Miller, I asked Mr. Jalali, if they would be bothered by the water that is spewing out from that detention pond. I will leave it to the court to determine if they were being truthful when they said they wouldn't mind living next to that and having that water spew out and affecting their property for days on end, that the yard could not be used. 41-1-4 provides that a private nuisance may injure either a person or property or both, and for that injury, a right of action accrues to the person who is injured or whose property is damaged. The right of enjoyment of private property being an absolute right of every citizen. Every act of another which unlawfully interferes with such enjoyment is a tort for which an action will lie. That's 51-9-1. As mentioned before.
Wait, I'm sorry, 51-9-1.
The distinction between a trespass and a nuisance consists that the former being a direct infringement of one's right of property, while in the latter, the infringement is the result of an act which is not wrongful in itself, but only in the consequence of which may flow from it. And that goes to the direct issue of all of these arguments that this work was approved and passed and sanctioned by the city of Alpharetta. It may not be illegal, and it may be, we'll find out soon enough, but it doesn't have to be illegal for it to be a nuisance. In the one case, the injury is immediate. In the other case, the injury is consequential and generally results from the commission of an act beyond the limits of the property affected, which is what's going on here. Their actions on their property are having an impact on the Asenova property, and to the point that the Asenovas have an adequate remedy of law. I'd like to know what that is. I don't think the issue is they can go stick dollar bills in that hole and stop it, if that's what Mr. Malavi is getting at. I don't think they can cross the property and do anything. I don't think they can do any physical act to stop that water, and no money unless they built a wall on their own property and diverted the water somewhere else, if that's what he's getting at. And of course, that would create all sorts of other issues. I don't think the law contemplates that they have to do that. The evidence was very clear that all of the injuries that are taking place on the Asenova property are the direct result of that detention pond and the way that water is now coming out of the one top orifice. There have been no calculations by Mr. Miller as to consecutive rain events, which may be benign or small in nature, but are cumulative. Your Honor, there's been a lot of discussion of sheet flow versus concentrated flow. I would present to the court that what we have here is a situation of concentrated sheet flow, perhaps. This property came across from the Pinemont property over the full length of the border between the two properties, and it flowed above the ground, and it came onto the Asenova property. It is now being accumulated or concentrated in that detention pond, and it does not have the full length of the property line to come across as it did before. It's now concentrated in that pond. It's coming out. There's no way that it's not concentrated. At the very least, like I said, it's concentrated sheet flow, and it clearly is concentrated, and it clearly is more than was ever present before that detention pond was built. A trespass as to water runoff cases, although the property must accept natural water from adjoining lands, an artificial increase or concentration of water may give rise to a cause of action. In surface water runoff disputes where there are two adjoining lots, the lower lot owes a servitude to the higher lot to receive water, which naturally flows from it, provided the latter has done no act to increase such flow by artificial means. Thus, although the property must accept the natural runoff of water from the neighboring lands, an artificial increase or concentration may give rise to a cause of action. And this is from Newton's Crest Homeowners Association versus Camp, and that's found at 306 Georgia Appellate 207, and that's a 2010 case. And these numerous videos have showed that the actions by the defendant have artificially created a change of the water flow. Defendant has argued, at least initially, that there's no engineering or expert evidence to support the claim. That is not the case in Georgia. That's not the law. The cases of DeKalb County versus McFarland, 231 Georgia 649, 1974, Ponce de Leon Condominiums versus D. Girolamo, 238 Georgia 188, Newton Crest Homeowners versus Camp, just cited, 306 Georgia Appellate, In fact, in the Ponce case, the defendant argued the very same thing that's being argued here, that they introduced expert testimony that their design could not, in theory, have resulted in accumulation or discharge of surface waters in excess of what existed before. In the Ponce case, the plaintiff testified and provided photographic evidence of the conditions before and after the development. The court found the jury could certainly decide if there's a problem that needed to be enjoined. There was no need for expert testimony to show that any calculations were made that there was an increased water flow. The other argument that defendant continues to make is water flows downhill. No one disputes that water flows downhill, but this is now concentrated water that's flowing downhill over a 14-foot area and affecting the plaintiff's property. What we'd like to see, Your Honor, not just a $2 elbow from Home Depot directing the water onto this splash pad, because that will not solve the problem. We'd like an order that prevents that detention pond from discharging in any manner toward the Asenova property. Let them implement their plan, which they say, and they were ordered by the court to provide a permanent plan at the first hearing, to discharge the water from the west. And then if that solves the problem, then we're left with an issue of damages. But and if that doesn't work, then they shouldn't be building houses where that detention pond can ultimately be relocated. We'd like an order that no water discharges from the west side. We'd like an order that until they complete the construction of a system from the west side, that they stop building property. So in the event that nothing that they come up with works, then they need to move that detention pond on either lot 4 or 5 and stop this water flow onto the Asenova property. Thank you.
Okay, now I've got a lot of questions that I would like to ask counsel. It has to deal with the evidence that has already been presented. But before I make a decision, I'd like to really make sure I understand what I've heard. And so kind of going back to the last thing Mr. Beerbaum said, my understanding when you compare the testimony of Mr. Ray to Mr. Miller, or let's just look at the testimony of Mr. Ray, is that basically he is concluding that because of design failures, that, and this is very rudimentary, but that the water's got to go another way, or for lack of a better word, or he actually said relocate the pond, but that the water go another, either back up. It's got to go somewhere. I think I heard Ms. Asenova and maybe Mr. Ray testified that there was discussion, and this isn't settlement because this was actually testified to, that there'd be a pipe placed under the Asenova property that redirected the water to some other form of outlet not on their property, as in a storm sewer or something. So I want to kind of understand where we are, because I think I won't say temporary basis, but it is temporary because it's not final. Are we talking about the water going someplace else entirely or going under their property?
No, Your Honor, the testimony was that after the first hearing, there was a meeting, there was a discussion to place a pipe by way of an easement, which was discussed way back when, years ago, or a couple of years ago, when the city council said, go get an easement. The Asenovas in June said, under no set of facts do we want a pipe on our property. We are not giving an easement. And then Mr. Miller testified that, or Mr. Jalali, that there's a new plan to pipe the water from the west. So the wall and the discharge now is to the east. Their plan now is to keep all the water from the pond on their own property, Pinemont, pipe it to the west and tie into an existing stormwater outlet, which is, I think, between lots 4 and 5, if that helps.
You're not suggesting that's what the defendants are asking to do.
They're not asking that, but that they testified that there was a new plan that would pipe it out the west side.
Okay.
Your Honor, if I may speak?
Yes, please.
There is an alternative plan that was developed, but the only reason that was developed was to counter the assertion, the completely false assertion by the plaintiffs and Mr. Ray, that somehow Mr. Jalali had started to build a house on lot 4. And the only reason he started building on lot 4 is because lot 4 sold. But they were, without any evidence, they suggested that there was some sort of plan, nefarious plan on the part of Mr. Jalali to start building, and this is in their pleadings, Your Honor, to start building on that lot in order to make it impossible for anyone, or at least impracticable, for you to perhaps to order that the detention pond to be moved to lot 4 because Mr. Ray incorrectly had concluded that that was the only option. So my client went back to Mr. Miller and said, all right, if there were a problem here, and if we were causing it, none of which is agreed upon, is there another way that this water could be channeled? And so, yes, a plan was developed to take the water around, I can't remember my geographical directions now, but around and away from the Asenova property and discharge it elsewhere into municipal municipal water. But if I may just say one other thing, what Mr. Mirbaum articulated to you just now by way of what he's asking you to do is to completely stop all the water.
Yeah, I got it. And
which is never, that's an improvement, Your Honor.
Just a second, stop. I'm not reopening your argument. I wanted to make sure I understood the question, or I wanted to understand exactly where it was, because my recollection and the notes that I wrote myself as we finished back in December suggest that the alternatives were water goes another direction or water goes under the Asenovas.
May I speak? Or the alternative to what, Your Honor? There is not, there hasn't, I mean, I guess if I may just have your indulgence, if we're going to speak in those terms, at least let's have an understanding that that I'm saying that assuming there is a problem, assuming anything needs to be done. We don't think anything needs to be done. This system is working.
Okay. I share with you the concern that one of Mr. Bierbaum's last statements was, we want an injunction stopping the water altogether, because I think there is an equal principle in Georgia law that you not increase nor decrease the water flow from your property to your downstream neighbor. Okay, so let's kind of parse this out, because if I'm trying to figure out my notes from before, and I think I have now, on a temporary basis, am I going to make Mr. Jalali relocate the pond? No, I'm not going to do that on a temporary basis. Is there an option for a better solution that would reduce the Asenova's damages? I'm not going to do that on a temporary basis either. I don't think I have the power to order them to accept a pipe underneath their property or the easement, as you were suggesting. Ultimately, I think, and candidly, this is somewhat the defendant's position, but hang on just a second, let me get it all out. Candidly, I think we are ultimately talking about damages. Not that that's necessarily an adequate remedy at law by any means. I'm sorry. I don't know how to stop that. Not that I think that that's an adequate remedy at law, but I mean, ultimately, that's where we are. The purpose of the second interlocutory injunction, I thought and hoped, was that if there was anything that could be done right now, that should be done right now, we not just wait until the Asenova's house ends up down the street in a flow of water. Can Mr. Jalali make them whole if their property is, quote, totaled? Of course he can. And a jury, or I will make him. Obviously, I hope something else happens to not make that necessary. So my thought was until Mr. Mojave started talking about nebulous, which is true, which is a good word. My thought was, yes, extend the injunction, extend the temporary, or the TRO, I guess, to an interlocutory injunction, which does the following, and it uses the exact same language, which is prohibited and enjoined from allowing or permitting concentrated water flow onto plaintiff's property in a concentrated manner, regardless if the concentration is above ground or subsurface. And it goes on to say they will take necessary, yes, I'll extend that. And I will make it for whatever time that is, which I think I'm entitled to make it up to 12 months. Y'all can correct me. So yes, it's extended. Is to whether I'm going to make them relocate the detention pond, I am not. What else do we have to talk about today? There was
Your
one.
Honor, the first order required the defendant to present a permanent plan, if I remember correctly. And I don't believe that's ever happened. And that's part of the issue, because what's going to happen next is, as of now, the only discharge point is that top orifice, and which we contend, once water comes out of that, they will be in violation of your order. And then the next motion will be a motion for contempt.
Fine.
Right.
I don't know how else to do it. Are they in contempt right now?
I believe they are. I mean, that's why I believe they are. But because of the timing and the pandemic, by the time the issues arose, the first order had expired. So they technically weren't. So now I have more time. So I guess if the next rain event that spews the water out, it's a motion for contempt. I was hoping for a little more from the court, a mandatory injunction to require them to pipe it out the west side, which their own engineer says would solve the problem.
Well, Mr. Beerbaum, I just asked you a moment ago if my options were relocating. I'm going to go back to Mr. Ray's testimony. His testimony was on page, well, you don't know the page of my notes, but his testimony was that the design of the July 9th, 2020 report is flawed. They have to relocate the detention pond. Now the middle discharge outlets are closed. The defendant's status report, rain events are more than 4 inches are a problem. So, I mean, again, I asked you before, are my options to relocate the detention pond or put a pipe under there?
No, I might have misunderstood, Your Honor. I believe there may be a disagreement between Mr. Ray and Mr. Miller as the efficacy of piping from the west side. But at the end of the day, it's their property and it's an issue they have to address. If Mr. Miller believes that piping from the west side will solve the problem, regardless of Mr. Ray's opinion, then I would ask that the court say, fine, do that. That is the permanent solution, according to them. That will solve the problem. That will not require a removal of the detention pond, which I certainly understand you would be very reluctant to do, but that would potentially solve the problem, at least according to Mr. Miller. The water would not flow toward the Asenova property. And then all we're left with when this comes to a hearing is what has been the effect of whatever's happened to date. So if the order goes a little further and says, please implement your plan to pipe it from the west, then we're not going to be faced with a contempt motion in a couple of months.
Where was that testimony tendered by Mr. Miller?
When I think Mr. Miller testified, or Mr. Malavi was asking about this plan, and Mr. Malavi just discussed it, that they don't believe they need to do it, but they did implement a plan. And Kavi, correct me if I'm wrong. I thought Mr. Miller testified about that.
That's correct, Your Honor. As I just indicated, a plan was developed in order to show that the plaintiff's contentions that the only solution, if there is a problem, the only solution is to move the pond onto lot 4, which is where Mr. Jalali had started to build, was part of this conspiracy to prevent that from happening. The only reason that we had that design prepared was that. And by the way, I'll point out that if that plan is implemented, the Asenova property will be receiving practically no water, certainly substantially less water from the Pinemont property than when the Pinemont property existed in its natural state. And that's just wrong. They're not entitled to that.
Okay, I'm looking back at my notes from December, and Mr. Miller testified on direct that discharge is being piped to west, to south, then into storm drain. Is that what you're talking about?
Yes.
And that's not occurring. That's not occurring now.
Right. The Asenovas are on the east.
Okay.
The west side would take it out.
Loss of a lot?
I'm sorry?
Would that mean the loss of a lot to Pine?
No, Your Honor. There's an existing storm drain. The only reason we mention the house is because Mr. Ray was of the opinion that the plan to pipe from the west that Mr. Miller designed would not work, and therefore the only other solution is to move the pond. It has to do with the grade of the property. It seems like it goes uphill. This goes back into the subdivision. But if Mr. Miller says that plan will work and you can pipe it out the west side and you don't have to move the pond and there's an existing storm drain to tie into, we would ask that the court say, fine, implement the plan. That's your final resolution.
If they're not doing anything on a fire, number one. Number two, if that's how they think they need to solve it, then they need to be in compliance with my order. I'm not going to order them to do that. I'm going to order them to not trespass. I do think this is a continuing trespass, and I do think it's a nuisance. And don't sit, Mr. Malavi, I think the world of you. Mr. Jalali, I think the world of you. But don't tell me that they haven't increased the runoff. I mean, if a jury sees this videotape, I'm just telling y'all what you already know. So I can't do anything about the damages portion of it. That's going to be a long way off. I have begged you to try to find some other way to resolve this. And candidly, if it's a pipe underneath their property, that's going to factor into a jury's decision too. Maybe that they didn't want to do that when that might have solved it. Now, if that's going to reduce the value of their property, then that's where we start writing checks. That's up to y'all. But I'm not going to order them to do what they might think would solve it. If that would solve it, they know to do it.
All right.
People out, a jury's going to deal with it. Unfortunately, and I think you can make the best argument in the world, Mr. Malavi, that they can't show you a videotape from before construction started until now, until after construction started. And I don't think a jury's going to care one bit. I think a jury's going to look at that videotape, Mr. Jalali, and I think they're going to ask for a calculator, but that's one woman's opinion. Right now, this judge is telling you to stop the increase of water onto their property. If the elbow works, I mean, I get that. I'm absolutely baffled why you haven't already done it, but
we will.
Maybe I don't get the strategy. That's not for me. But I think that the other side of the other thing that that the Asenovas need to realize, that Mr. Beerbaum, I'm sure, has already told them, is we're not anti-development in this county. We want houses. We want good neighbors. We want nice land. Maybe everybody would love to live next to a deer inhabited, lovely set of woods, sure. But that's not what happens in our economy. We build and we live and we have good neighbors. And a jury feels that way as well. Okay, guys. Let me know how the depositions work out.
I take it that the court will issue this order. I don't need to draft one up. It's pretty
Yeah,
similar
you
to,
need to draft one and
oh,
and circulate it to Mr. Lobby.
all right. And you said 12 months this time, right?
Yep.
All right. Thank you, Your Honor. May I be excused?
Well, wait a minute. Is
Oh.
there anything else we need to talk about? Is there any way I can help? I know that